Hey everyone, this is Kevin Hodge, the Vision Mindset CEO. Now let's get into it. Most people think you need a courtroom, a judge, or a hearing to challenge information on your consumer report. But here's the secret that every consumer should know and every agency hopes that you don't figure out. You already have cross-examination rights right now without suing anyone or filing anything in court. Full explanations from trained personnel about any account, any inquiry, anything that appears on your consumer report. How to force Equifax and TransUnion to explain consent they never had and notices that were never delivered, and the statutory requirements they routinely miss. Let's get into it. On paper, Section 12.4 looks simple. You have the right for explanations by a trained personnel for any information that appears on your consumer report. This isn't "we'll get back to you in a 30-day email." This is a statutory obligation. You can require an agency to explain why the account appears. What did they use to verify consent? What happens if notices were not received? Were there any restrictions applied under Section 11.3? And most importantly, you can ask questions and they must tell you in detail the explanations to their answers. Section 12.4 turns your complaint into a cross-examination without a courtroom, without a judge, and without a hearing. Now let's talk about Section 10.12, their Achilles heel. Before a consumer report is accessed, the lender must deliver a specific notice, and that notice must be served upon you within Section 21 of the Consumer Reporting Act. That allows to serve the notice personally, regular mail, registered mail, or any other manner where they could prove receipt of notice. Which means when you ask, they can't explain how the Section 10.2 notice was served. And if notice wasn't delivered, they can't demonstrate a permissible purpose under Section 8.1 DI. And if the permissible purpose fails, then it's restricted under 11.3. Your questions under Section 12.4 exposes that failure immediately. Credit agencies love internal records. They love CRM screenshots, internal notes, anything that benefits their position. But none of those things satisfy Section 12, Section 13, Section 9, Section 8, or Section 10, or Section 20. Here's what nearly every CRA and lender does wrong. They use an application as a consent form. They use a screenshot as consent. They never deliver a Section 20 notice. They never show a Section 10.2 notice. Under Section 12.4, you expose all of these issues. And when they can't answer, you create an evidentiary chain that exposes that they can't verify consent, can't show or prove that notice was given or delivered, verifies unauthorized access, and no statutory notice. Reporting in breach of Section 8, 9, 10, 11, and 13. All for one statutory right. The explanation from a trained personnel. Let me break it down clearly and simply. Section 10.2, if there's no notice, there's no permissible purpose. Section 20 requires proof of receipt. No proof, no notice. Section 11.3 restricts reporting when Section 10.2 notice wasn't delivered. Section 12.4 gives you the right to demand explanations. Section 13 requires them to investigate missing notices and provides a documentary basis for their decision. When agencies or furnishers skip these steps, then the statute is on your side. Here's how to turn your letter into a courtroom level cross-examination. Step 1, identify the account. Step 2, list the missing documents. No Section 10.2 notice, no time-stamped evidence, no delivery, and no proof of receipt. Step 3, ask the required explanations. Explain how Section 10.2 was satisfied. Produce the exact notice relied upon. Identify the delivery method and provide proof of receipt. Explain why the continued reporting is not restricted. Provide all the reports access. Explain the results of your investigation into the missing notices. Step 4, Keep the response for escalation. Evidence for the privacy commissioner, evidence for the ministry, evidence for statutory damages, evidence to have the entry removed or restricted, all without having to go to court. So here's the takeaway. Section 12.4 isn't a consumer right, it's a cross-examination tool. A legally binding mechanism that allows you to force trained personnel to explain every missing document and anything that's on your consumer report. Use it. It's the fastest way to expose non-compliance and unauthorized access to your consumer report. If you want, I'll build you a full 12.4 cross-examination module, a visual flowchart, side-by-side comparison of proof of receipt or internal record, a closing argument you could use in complaints or escalation letters. Just tell me and I'll produce the full module. Thanks for watching, and be sure to check back for more videos just like this.